Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm EDRM CEO and Chief Legal Technologist. Today's webinar is a collaboration with our trusted partner, eDiscovery Today, titled Important eDiscovery Case Law Decisions for November 2025. This monthly series is in its sixth season. Our faculty experts are Doug Austin, Tom O'Connor, the Honorable Judge Andrew Peck, and myself. We're recording today's session for future on-demand access, and slides will be available after the webinar. This webinar, along with all of EDRM webinars, will be available on the EDRM Global Webinar channel for the next quarter to help support your ongoing learning and reference needs. Questions will be answered both during and at the end of the webinar. Holly Robinson, EDRM Senior Marketing Operations Manager, is here with us. Holly, can you please share what resources are available today?
Thanks, Mary. And we're loving On24 with so many ways for you to engage. If you look at the bottom of your screen, you'll see the console. The question mark icon is where you can type your questions for today's faculty, and we highly encourage you to do so. You'll also see the paperclip icon. If you click on it, you'll find today's resources. You can download the On24 engagement tool descriptions to help you better engage with the platform. There's a link to subscribe to the eDiscovery Today blog, an excellent way to start your day. You'll also find a link to learn more about the Honorable Judge Peck and how you can engage with him. Right below that, there's a link to get your copy of the new book from Tom O'Connor and NextPoint, Artificial Intelligence for the Rest of Us, which is their latest project following their earlier collaboration, eDiscovery for the Rest of Us, the Checklist Manifesto. You'll also see a registration link for next month's case law webinar, Most Important eDiscovery Case Law Rulings of 2025, happening December 18th, and we'd love to have you join us again. And be sure to register for our upcoming webinar tomorrow, How to Win Cases with Compelling Visual Presentations. If you'd like to learn more about today's faculty, click on the speaker bios and they'll pop open with more details about our presenters. And just like on Zoom, you'll see the smiley face emoji and lots of other reactions. We'd love for you to engage with them. Finally, click the LinkedIn logo to follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Holly. All opinions expressed here are faculty's own, not those of their firm or clients, and no legal advice is being provided. Today's faculty includes Doug Austin, the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Doug is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving J.D. Super Reader's Choice Award as the top eDiscovery author and top cybersecurity author. Doug has presented at numerous webcasts, events, and the best of conferences. Tom O'Connor, the director of the Gulf Coast Legal Technology Center, is also a nationally known consultant. He's a speaker, writer, and all things in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes, including the plaintiffs in the BP litigation. He's been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. Tom hosts with Rocky Messing the eDiscovery channel on YouTube, and he's the author of Artificial Intelligence for the Rest of Us and eDiscovery for the Rest of Us, the Checklist Manifesto, both published with our trusted partner, NextPoint. And the Honorable Judge Andrew Peck is a Band 1 Chambers Rank Senior Counsel at DLA Piper, serving 23 years as a United States Magistrate Judge for the Southern District of New York. Before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters with extensive trial experience. And at DLA Piper, Judge Peck advises on those copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues, information governance, cross-border discovery, and other things from a judge's perspective. Sought out as a conference speaker concerning e-discovery issues, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on e-discovery issues. EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And Doug, I understand you have a couple of cases you'd like us to discuss.
More than a couple, Mary. Hi, everybody, and welcome to our November case law webinar on the EDRM network. As always, we have 6 unique cases to discuss this month, and those cases address disputes related to production of contemporaneous hyperlinked files, compliance with an ESI protocol, waiver of privilege on emails after the sale of a server, sanctions for failing to conduct a reasonable search for ESI, production of databases in native format, and discovery of outtake footage for the True Crime Program Dateline. Of course, we do welcome questions, and we'll try to get to as many as we can, and we'll send out a copy of the slides after the presentation, so look for that too. Of course, as Mary mentioned, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. That's true for every version of this webinar, even the contemporaneous version.
Nice.
And here's a quick, there we go, a precursor. Here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling itself. These case law rulings are available courtesy of Minerva 26, which is a great resource not only for case law, but also for federal and state rules, checklists, and forms, and a glossary of legal and e-discovery terms. Minerva 26 has over 44,500 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for e-discovery case law out there. So with that said, let's get into the cases. This first case is the latest in the growing list of cases involving discovery of hyperlinked files, and it's one that may be a game changer. In it, plaintiffs requested a copy of Google Drive hyperlinked documents as they existed at the time when emails were sent. Defendants asserted that Google Drive documents are designed to be modified by users over time, so it was highly unlikely any technology, including plaintiff's program, Forensic Email Collector, would find them as they existed as a certain point in time. As Arizona Magistrate Judge John Boyle stated, plaintiffs state that defendants refused to produce versions of hyperlinked documents contemporaneous to emails that were sent during the relevant period. Defendants only offer the current version of those documents that may differ from what the parties to the emails saw at the time because of edits made over the course of the ensuing months and years. This inhibits plaintiffs' ability to establish who knew what when. Judge Boyle also referenced a previous court order governing production, stating, "The parties understand that hyperlinked documents will be collected and produced in this case. Where the automatic collection of the hyperlinked document is technologically feasible, reasonable, and not unduly burdensome, the hyperlinked document will be collected." He also said the court recognizes that the collection of hyperlinked documents existing as they did at the time of email presents challenges. The court acknowledged the potential for these challenges in the ESI order. While defendants insist the process will be difficult and that whatever documents FEC collects may lack evidentiary value, the court finds a diligent and collaborative solution in the spirit of the ESI order requires a compromise. And this is a sentence to remember from this ruling. The court will not excuse defendants from any efforts to produce contemporaneous hyperlinked documents outright simply because they elected to use a suite of cloud-based web applications that would make that process difficult. So Judge Boyle ordered plaintiff to select up to 2 custodians with defendants to produce responsive documents, i.e. the versions of any documents as closely contemporaneous to but preceding the email communication as is feasible on or before December 1st. So Tom, do you think this case will spark a trend where courts not only expect parties to be able to produce hyperlinked files, but also contemporaneous hyperlinked files?
Well, I hope so, because I don't know about you, but I'm kind of getting sick of hearing arguments about this issue. you know, because the arguments get to be so just discombobulated. People just are we're getting into a technical area oftentimes that gets misunderstood and then sometimes misstated in the arguments. I thought the judge's statement there about, you know, you're going to live with what you chose to use in terms of preserving these documents. And if you chose something that doesn't do it, then that's the way it is. That's still your problem. You have a duty to preserve. You have a duty to produce. So you're going to have to do it. Now, that being said, when we talked about this a couple of times in previous months, I forget which one it was, Doug, but I had sent to me an order in one of the Tesla cases by Andrew McDivitt, who's an attorney at the Walkup law firm in San Francisco. And they had come to what seemed to be an agreement with the other side that was in that particular case. That was the McLaughlin versus Tesla, an order entered by Magistrate Judge I hope I pronounced her name right, Van Kulen, where basically the parties agreed to do 25 hyperlinked documents at a pop. So somebody would identify 25 documents that had these hyperlinks, and they would work through those instead of coming back with, you know, we've got hundreds, if not thousands of documents, and how are we going to start this? What are the most important? Identify the ones you want the most, limit it to 25, and we'll work through those and finish working through those before we go to the next 25, if there are another 25. And that was sort of a if not collaboration, certainly a cooperation between the parties, which I think was a really great way to resolve it. Andrew tells me they've come to a similar order in other cases since, and that was in 23 when that order was entered, and they've used that similar type of order in other cases. So I think we've got a framework to deal with this now, both a technical framework, an order by the court, and a model type order that puts some substantive sort of cooperation into handling this in a reasonable manner.
Yeah, I agree. Yeah, you mentioned that compromise of 25 at a time or some number at a time. In Ray Uber, the earlier ruling we covered was another case where, after all the discussion and everything that went into that, they ultimately came to a similar kind of compromise of identifying a certain number on a periodic basis, and that seems to be becoming more of the trend here. But it's very interesting that on this one, the judge really pushed more for, hey, you've got to make the best efforts to produce these contemporaneous versions, and let's start with 2 custodians and work from there. So that one makes it a little bit different.
When this issue first came up, I don't know, well over a year ago, meaning some parties were saying it's impossible. It's impossible to do. So it can't be done, so they refuse to produce. So I think you've got judges, as we do in this case, Judge Boyle, pushing to say, there is a solution. There are solutions, and you guys work it out.
Yeah, absolutely. So Judge Peck, obviously discovery is supposed to be both relevant and proportional. So with a situation like hyperlinked files, what responsibility, if any, should the producing party have to facilitate proportionality?
Well, I think, we come back to cooperation, as we often do. At a minimum, discuss with the requesting party what the producing party can do in the regular course of business, and then what else it can do, knowing the technology that it's using, et cetera. So, and if you're disclosing, we are using Microsoft or we are using Google such and such, that gives the requesting party the ability to go to its Tom O'Connor expert or other expert and learn what the system can do if the responding party is saying it can't do it. But the one caution I would give here is that, corporations are in the business of, selling cars or, whatever else it may be, not litigation. And you can't say that the litigation tail should wag the dog of your regular business. That may depend on how frequently the company is in litigation. You know, if it's a one-timer, that's one thing. If it's, you know, the usual suspect, that's always going to be in litigation, even if that's always on the defense side. So it's not like it is starting litigation, but it's in the other business of responding to litigation that may create a different situation. And I do think courts have to be aware of that and not impose burdens that go well beyond what the company would be doing in the regular course of business.
Sure, it makes sense. We've got a question from the audience. So instead of a business decision, the decision for email and storage solutions is now an eDiscovery mandated decision, question mark. I guess you would say not necessarily just because of this one case, Judge Peck?
Yeah.
It's a legal decision. It's not a business decision or an eDiscovery decision. There's an obligation that goes back to the common law to preserve documents that are needed in the scope of litigation. If you are a type of business that's going to be involved in litigation, that's going to be part of your business decision. Is what do we have to do to preserve things if that legal imperative arises?
Yeah, very interesting. So Mary, if you're an organization that's using cloud-based platforms with hyperlinked files, what does a case like this do to change how you prepare for litigation involving these platforms?
It's a good question, Doug. I hear Tom on this, and the first thing, of course, to do is to determine claims and defenses and what evidence will support both, and certainly archive that which helps and which hurts, and do that as perhaps a point in time backup, a backup collection, preserved by collection, if you will. And once that legal hold is in place, automate the archiving of messages and the linked attachments for those individuals and departments that are under hold. And then be really, really careful with requests for to admit, and sequence your discovery if you can to have the hyperlinked files come last, so that the scope may be narrowed, the custodians may be narrowed, date ranges, etc., so that you can minimize what you're doing there. On the proactive side, you should definitely test your collection of versions of the same attachment so that you can represent what is happening with your system appropriately in the 26F conference. And then also for authentication, you should research archiving systems and get one. Especially if you're a regulated industry or a frequent flyer, as Judge Peck described. And then if you're a big enough client, advocate for a version identifier in the metadata of your emails, a version identifier for the attachment, so that you can more easily retrieve and identify those hyperlinked files.
Those are all great tips, and certainly this is an issue that's even though Tom's sick of talking about it, it's not going away anytime soon. So we'll certainly be interested to see what happens here, and probably we'll continue to see cases involving this issue for some time to come. And certainly people are still very passionate about it. But we've got 5 other cases, so we'll move on to the next one, which is a case where the plaintiff was reportedly unsuccessful in attempting over several months to obtain defendant's consent to an ESI protocol. The court then ordered the parties to either file a jointly proposed protocol governing production of ESI, or if agreement couldn't be reached, their respective proposed protocols and or a statement setting forth why such protocol is unwarranted. Plaintiff complied with the court's order, filed its proposed protocol, but defendants didn't comply, prompting the court to issue an order to show cause why they shouldn't be sanctioned. Following receipt of defendants' respective responses to the show cause order, the court entered plaintiff's proposed ESI protocol. Then plaintiffs subsequently sought an order enforcing provision of search terms and custodians used to identify responsive materials, as well as a corresponding hit report. During the discovery dispute conference, defendants didn't object to complying with the provision, but requested the court enforce the provision upon all parties and provide clarification concerning the phrase hit report. California Magistrate Judge Christopher Baker stated, in resolving earlier discovery disputes among the parties, the court has confirmed that parties appropriately may seek discovery on an adversary's discovery efforts, including through production of information revealing search and collection methodology, search terms used, and sources searched. So we required both parties to comply with paragraph 5 of the ESI protocol, stating, specifically, each party shall provide the others with search terms and custodians used to date to identify responsive materials within the producing party's ESI, as well as a corresponding hit report that shows how many documents, exclusive and inclusive of families, contain each search term or string. He also added, the court declines defendants' invitation to further define terms such as hit report and families as a reasonably diligent search of this court's and the circuit's jurisprudence governing ESI reveals that the terms are commonly accepted. The other dispute related to the court's order for the defendants to provide amended responses to certain of plaintiffs' requests for production, where plaintiffs claim defendants' amended responses to its RFPs didn't include a privilege log, while defendants claimed they didn't reassert privilege and weren't required to produce a privilege log. The counsel for plaintiff represented during the discovery dispute conference that defendants asserted a privilege objection in response to other of plaintiffs' RFPs that were not at issue. So Judge Baker ordered defendants to provide a statement for each RFP response, whether any responsive documents are withheld and the basis for the withholding, i.e. whether attorney-client or work product privileges, and a privilege log for each RFP response where they claimed attorney-client or work product privileges. So Judge Peck, in this case, Judge Baker declined to define terms like hit report and families. Would you have done the same thing, and what level of eDiscovery understanding would you expect counsel to have in cases before you?
You know, part of it is you can't tell just from the opinion whether counsel was truly ignorant of what was meant by hit reports and families, or whether it was like being a wise guy making a ridiculous objection, playing games with the court, and we all know that the latter does not go over well. You know, I think the judge was right there in saying that those terms are frequently used by certainly the players in the industry, but sufficiently defined in judicial opinions and the like that counsel, if they really didn't know what was being talked about, could have looked up other case decisions on it. Before going on to Mary and Tom, the one other point I'd want to make about this decision is it's unclear to me whether the parties had really agreed to produce all of this information, or rather if the court had just ordered it in one of the prior orders, because this does seem to involve a lot of discovery on discovery, which generally we don't like.
Right. No, that's something I noticed as well. So it seemed as though this was one of those cases where we have a failure to cooperate, and the judge was having to kind of seize control a little bit. So, but yeah, again, it's not completely evident from just that single ruling. So important to note there. So Mary, why do you think defendants were so reluctant to negotiate on or even file their own ESI protocol? Wouldn't it be better to push for the position you want by actively participating in the protocol negotiations?
Well, I certainly believe that controlling one's own destiny is always a good. But I wonder if they thought, you know, they're law enforcement and maybe the judge would go easy on them or give them a favorable ruling and they wouldn't have to do the negotiation. But I think it's more likely they were under-resourced and undereducated. I think I mean, it's kind of embarrassing to put something before the court of, what's a hit report, or,
True.
so I kind of think they didn't know. And that's one of those things that if you don't know, you're supposed to get somebody who does know to be on your team and help you out.
I was fully expecting a Judge Peck bring your geek to court kind of comment there, but yes, absolutely. Whether you got to have somebody who knows, or go get somebody who knows for sure. So Tom, for the plaintiff RFPs where defendants did assert a privilege objection, should privilege be waived since they didn't produce a privilege log?
Well, as Judge Peck pointed out, it seems kind of uncertain here who agreed to do what. The defendants certainly were saying they didn't assert an objection on grounds of privilege to that RFP, to the amended responses to that RFP, and so they didn't need a log. And the plaintiffs countered with, well, they did assert a privilege objection in response to other RFP. So it wasn't abundantly clear exactly what had happened. Certainly not enough, I don't think, to say that they had waived privilege. And the judge, I think, just said, okay, let me be clear what I need to be clear on. I'm ordering you to give operative RFP responses to each and every one of them, and amend the responses with a statement for each one, and the basis for withholding documents, if any, and a privilege log if needed. So I think going forward, he's just kind of made it clear what's to be expected.
Yeah, and I think judges are and should be, protective of privilege and not let attorney incompetence or failure to communicate, let alone failure to cooperate, result in a waiver of privilege. Back in my Fisher against Forrest opinion, where I was railing against boilerplate objections, I said that, after that decision, if anybody used boilerplate objections in front of me, I would consider that a waiver of any objection.
Nope.
And then I said, except for privilege, that we'll treat separately, differently, whatever.
Yeah, no, that's a fair point. So since we're on a privilege discussion, let's talk about another case that deals with waiver of privilege. This case involves that consideration for 3 categories of documents, and it was suggested by Judge Peck and also covered by Michael Berman. Here, as part of an asset purchase agreement, the DAWS Inc. server was transferred to JDT. Plaintiffs contended that the APA transferred all data on the server to JDT, which meant the emails on the server were now their property. Jim Dawes, who was part of the sale of that, claiming not to be tech savvy, stated he did not intend to sell the data contained on the server, including business communications for his other companies and personal emails. Upon reviewing the server's data, Rick Fernandez, co-owner of JDT, claimed to have discovered emails between Jim Dawes and his attorneys outlining a plan to create a mass resignation of employees from JDT, receive additional value for what was already sold to JDT, and or devalue JDT to the point where Jim could reacquire it for far less than he sold it. So defendants filed a motion for a protective order on the emails. In response, Nebraska Magistrate Judge Michael Nelson stated, Nebraska law is unclear as to which party bears the burden of proving waiver or absence of waiver, and courts have reached differing conclusions on this point. In this case, regardless of which party has the burden to establish waiver, the court finds the outcome is the same: the attorney-client privilege was waived. Regarding the pre-sale email communications, he said that defendants do not address the voluntary disclosure of allegedly privileged emails through the sale of the server. Notably, after the APA, neither Jim nor his attorneys ever instructed JDT, Rick, or Ricky to delete any pre-sale communications. Through the asset sale, Jim voluntarily disclosed the communications contained on the server, thereby waiving the attorney-client privilege. As for emails he continued to send to his attorneys after the sale, Judge Nelson conducted a 4-factor test to determine whether he had a reasonable expectation of privacy, finding with respect to company policy on email use, company's right to monitor, third-party access, and employee notification of policy that Jim Dawes did not have a reasonable expectation of privacy in his post-sale email communications, so the attorney-client privilege was waived on those as well. And for 2 emails that sent by Jim Dawes' attorney to his old work email address on October 1st and October 9th of 2024, after his employment had ended, Judge Nelson stated, defendants provided no evidence of reasonable steps taken to protect the emails from inadvertent disclosure, nor do they provide evidence of reasonable steps taken to rectify the error after learning of it. As such, the court finds the inadvertent disclosure operated as a waiver of the privilege in these October 2024 emails. So Mary, Dawes had long used a law firm as personal attorneys and as attorneys for his various companies. Do you think they bear any responsibility in failing to instruct him to remove any correspondence to them before the sale or avoid continuing to use his work email to communicate with them afterwards?
I would say yes, yes, and 1,000 times yes. And and not only the advice around not using his email, continuing to use that same email and storing it on that server, but to put language in the M&A documents that the data is, if it was all the data was his, or at least the privileged data was his. So that there's at least an ownership argument there. Informed M&A teams oftentimes dip into the emails of their targets to ascertain what the culture is, to see if there are hidden problems, things like that. And they put protective orders, attorney's eyes only protocols out. And it seems like none of that was done here.
No, certainly doesn't. And it doesn't stop there, Tom. Not only was there a failure of Dawes' attorneys to instruct him on removing emails to his attorneys before the sale or using a different email address after the sale, but they also sent 2 emails to his work email address after he resigned from the company. Does he have a case for a malpractice suit against them?
So 3 different issues, right? We got the client property, and then two sets of emails, 2 types of emails. So the first one, and I'm not obviously a Nebraska attorney, but the Nebraska bar rules tend to follow generally, as far as I could determine, the duty to safeguard client property in the ABA model rule 1.15. The Nebraska rule is, I believe, if I can read my own writing here, 3-501.6. But failing to advise a client to remove privileged data might be a breach, but it only rises to malpractice if it causes actual harm. And the 3 given examples are disclosure of sensitive information to third parties, loss of a legal advantage, e.g. waiver of privilege, or financial or reputational damage. So, I think certainly on that issue, I think we've got a basis for a malpractice claim. Regarding the emails, the ones sent by Jim Dawes after he became an employee, the judge went through a very detailed, specific 4-pronged test as to why he would waive the privilege on that one, and found it to apply. The only thing there is that they were sent by Dawes. So the one sent by Dawes, I don't know that there's a malpractice claim there, unless he's going to say he was failed to be advised. But the 2 sent by the attorney to the old trucking address, the judge said, as you said in the last paragraph there, they didn't take reasonable steps to protect the emails, and even after they knew, they didn't do anything to rectify it. So I think you may have a possibility of malpractice on that one as well.
Yeah, certainly seems like it. So Judge Peck, if there hadn't been a company policy banning personal use of company email, would at least Dawes' emails post-sale have still been protected by privilege, or should he not have had an expectation of privacy regardless of whether a policy existed?
Well, first, better to be safe than sorry. So whatever the law in Nebraska would be on that, he should have thought through all right, I'll continue to use my work email since I'm still working there, but not for communications with counsel, particularly if they're involved with, should I be suing the company? I mean, that's just dumb. And I could leave it at that, but, in the employment context, and this was not really the employment law context as much as what the, M&A deal was all about, et cetera. But there are conflicting cases. I remember a conflicting case in short order between a court in New Jersey and a court in New York about whether the employee's communication with counsel from the work email address did or did not waive privilege. You don't want to be at the mercy of the law on that. Just get a Hotmail account or a Gmail account or whatever it may be and communicate that way.
Yeah, couldn't agree more. First of all, for those who weren't here at the start, yes, we will provide slides, a link to the slides and a link to the video, either later today or tomorrow. So yes, you will get the slides. And then a question: how do you handle redaction on the audio privilege conversation? Redaction on PDFs or Excel spreadsheets, Word documents are understandable, but how do you redact audio recordings? While I don't think this one specifically dealt with audio that I know of, believe it or not, there's software to support and assist with redaction of audio recordings as well. Obviously, it's more difficult. Do any of you have anything to add to that?
Well, there's two distinctions there. There are a plethora of straight audio player files that will let you, including Windows Media Player, where you can go in, open up the audio file, and clip out sections. So it'll just give you a little slider that goes down minute by minute, and you can find the ones that you want to take out, and you can excise them. There are some more sophisticated programs. If the audio was done originally with a link to a transcript, that will let you go in and excise or redact the transcript and do the audio file automatically. Those are few and far between and tend to be expensive, but a lot more effective than the first option, which can be arduous and time consuming. Doug, you may have had to do it on some recordings at some time. I've had to once or twice for some of the recordings I did with Rocky. And for somebody who doesn't do that, for somebody who's not an audio engineer expert, it's tedious and it's not fun.
Yeah, but the technology is there and improving, and also the cost of it is going down, and
like everything else. Yeah,
absolutely. So absolutely. Yes, there's definitely a way, and we've got I would say plethora of other cases to cover, so we'll move on. To our next case, which was also suggested by Judge Peck. In it, the Friedman defendants moved for reconsideration of the court's order denying their motion to compel SoundAround to produce certain documents. The court held a hearing on the motion, at which time the Friedman defendants informed the court that a SoundAround witness who was deposed in September 2025 had identified a database called the Data Warehouse containing information pertinent to their sales and calculation of their commissions, and they contended that the testimony demonstrated that SoundAround had lied to or misled the court about the existence of data and failed to produce information that was responsive to their document requests. So they made an oral motion for production of data from that database so that they can compute their commissions, which they contended in their counterclaims were improperly computed. SoundAround argued that it didn't know about the database before September 30th, was not required to produce information from the database because it consists of raw data, and it would require it to create a document, which it contended is not required by the FRCP. And it also argued that the Friedman defendants should have identified the database and proposed search terms for it. In response, counsel for Executive Laundry interjected as an officer of the court to say that SoundAround's counsel was misrepresenting the data systems. The court, troubled by these developments, ordered Sound Around to provide a letter to the court explaining itself and the contents of the data warehouse, why it had not been identified earlier, and why data elements relevant to the computation of defendants' commissions could not be produced in the form of a spreadsheet or other format. New York Magistrate Judge Catherine Parker, finding it inappropriate to raise new arguments in a motion for reconsideration that were not raised in the initial motion, and also finding no clear error, denied the Friedman defendant's motion for reconsideration. However, with regard to the oral motion to compel, she said, Sound Around's counsel is absolutely wrong that it was not required to produce responsive information stored as data in systems over which it has custody and control. Federal Rule of Civil Procedure 34 has long required responding parties to conduct a reasonable search for documents and information relevant to the claims and defenses. I love this next sentence. Perhaps Sound Around's counsel has not read Rule 34 or case law interpreting it in the last 20 years, or is simply unaware of their ethical duty under New York Rule of Professional Conduct 1.1 to stay up to date on technology relevant to their practice and requirements of applicable rules of civil procedure. In granting the Friedman defendant's oral motion for production of data and ordering discovery sanctions in the form of attorney's fees and costs, Judge Parker stated, in sum, Sound Around and its counsel failed to conduct a reasonable search for relevant repositories of information, failed to produce relevant data concerning defendants' commissions, failed to comply with Rule 34's requirements by identifying relevant information that was being withheld on the basis of objections, and by failing to produce responsive data, misled defense counsel and the court as to the reasonableness of their search and the existence of information relevant to the computation of defendants' commissions, and failed to comply with Rule 26G that requires counsel to sign discovery responses attesting that they are complete and correct as of the time it is made. That pretty much sums it up. So, Tom, what do you make of the argument from Sound Around that production from a database isn't required by the FRCP? Was that a case of throwing an argument against the wall and hoping it would stick?
Oh God, I don't know what it was. I am flabbergasted, as apparently the judge was. The wording, first they didn't do this and they didn't do this and they failed to comply, and it just. At one point, and I'm not sure you quoted in here, the judge said that the briefing on their motion was, quote, cursory and convoluted, end quote. And I think that sums it up. It consists. The other one that struck me was, we don't have to produce it because it consists of raw data, and that would require us to create a document. Like I don't even know. I feel like those of us who have had children know what it's like to have an argument with a 4-year-old, and your first mission is to try to understand somehow, some way, what alternate universe they're living in that they're trying to make an explanation about, because I can't make heads or tails of this one. And I think the judge just cleared it up. Like you, my favorite line was, well, apparently you haven't read anything about any of this for the last 20 years.
The phrase "I have no words" seems to kind of sum it up.
Yeah, I think Judge Peck's favorite rule may be coming into play in this one, right?
Could be. We'll ask him we'll ask him to weigh in on that, as well as Judge Peck. One of the things I'm curious about is how common are oral motions to compel, and under what circumstances are they most likely to be accepted by the court?
You really have to look at what is the common practice and custom in a particular jurisdiction or before a particular judge. Very common in the Southern District in New York, and probably other districts where discovery is regularly resolved, not necessarily by formal motion practice, but by the short 3 to 5 page letter to tee up a dispute and then get in front of a court in a conference and deal with the arguments, and the court likely ruling on the spot. So yes, very common in the Southern District for the discovery requests to be just oral at a court hearing. As to whether this is a Rule 1.1 violation. 1.1 for our newer viewers is what I call the don't piss off the judge unwritten rule. And, I know Judge Parker well, and for her to say what she said about, you either haven't been aware of what's happened in the last 20 years, et cetera, she clearly was not happy with this lawyer.
Yeah, I think that's an easy one. So, Mary, Judge Parker issued fees and cost sanctions. Should the Friedman defendants push for additional sanctions, such as like maybe the inability for Sound Around to use the data from the database to support their case while preserving their ability to use it?
Yeah, we saw this in a previous case, didn't we, Doug?
Yes, we did.
But here, the judge is clearly giving Sound Around a big shellacking. And the judge used the must language to award the costs and fees. And that, to me, signals an openness for more sanctions if asked. All you need to do is cut and paste that portion you read, Doug, where, with the laundry list of transgressions and submit it. I think on balance, it would probably be, some kind of case impacting sanction would be appropriate.
Yeah, certainly seems like it. So maybe we'll see this case again. Yeah,
although, I can use the data and you can't, I don't know, just does not sound fair. So there may be appropriate sanctions to be imposed that are more case oriented as opposed to just monetary. But if you're going to do something like that, you've got to phrase it very carefully to not go from being the winner to getting the judge mad at you.
Mm-hmm. Yeah, absolutely. No, and we covered a case last month where one party was looking to use the documents that were late produced and not allowing the other one to, and the court rejected it in that case as well. So, yeah, definitely an interesting situation. And we'll move on to our next case, which also deals with structured data and occurred in my home court of Houston. In this class action, the class representatives sought certain databases in their native form from Concho's main data system, the Aries database. They contended the Aries database is Concho's main database that contains information relevant to the wells and revenue streams during the established class period. Defendants noted that during the lengthy 4-year litigation, they had already produced more than 207,000 documents, totaling more than 2.83 million pages. But the class representatives, contending that the discovery process should not be measured by quantity over quality, responded that the produced documents were cut and paste Excel spreadsheets of disorganized Aries output data that do not tie in to the other Excel spreadsheets, leaving the data incomplete and difficult for their experts to analyze, describing the production as a disorganized document dump. Texas District Judge Andrew Hanen used the 6 proportionality factors to decide this issue, finding as follows. The issues at stake weigh in favor of broad discovery because the issues at stake in this case are undoubtedly important to deter corporations from misleading the public. The amount in controversy of a potential $2.3 billion weighs in favor of broad discovery. Third, Concho has the exclusive access to the Aries database. And fourth, Concho has the resources to produce the requested data. Fifth, the requested Aries databases are reasonably calculated to lead to the discovery of admissible evidence, there's that term again, related to falsity and scienter. And finally, the most important factor, the burden of production does not outweigh the likely benefit of the requested data, given that the class representatives are entitled to access a workable version of the Aries databases that were used by Concho employees to distribute the Excel spreadsheets, and the court not finding the arguments about the burdensome process to produce the data convincing, so he ordered Concho to produce the databases. So, Judge Peck, do you agree with the ruling, given that it's technically contrary to Rule 34B2E3's statement that a party need not produce the same electronically stored information in more than one form?
Yes, I do agree, and that the one form rule is dependent on the trigger. So what I mean by that is, how did the plaintiffs request the data? How did the defendants say they were going to respond? Or, as I think may well have happened here, there was a request that said produce information about the wells, et cetera. And the other side then, started producing data, including lots and lots of junk. So we don't know from the decision itself what was requested and whether that would trigger the one form of production. Obviously, if there is no discussion and you just produce junk, you then can't say, well, now that you've caught me and but one form production only, no, doesn't work that way. So I think there's, fine with what the judge did here.
Okay. By the way, Carolyn points out that it's actually Judge Haanen, not Judge Hanen. So I missed that. I tried to look up the pronunciation of the name, but I forgot to factor in the Texas factor. So there we go. Must Haanen, maybe Haanen down here. So Mary, it's fairly common for parties to produce spreadsheets from databases instead of the databases themselves. So how could the defendants have handled this production to minimize the potential for it to be, as the class representative stated, a disorganized document dump?
Well, it certainly adds some organization to it. The databases have column names or field names, whatever you want to call them, and use those in the spreadsheet. And you could use a more friendly name if you want to, but by using the same name that is used in the database, that's a step towards being able to tie those spreadsheets to the actual database. And then you can also provide the queries or pivot table documentation, however those spreadsheets were originally produced, and that would make it clear that the data wasn't cherry picked, for the quality of what it's saying about your case, as well as maybe a date range or something like that. And then also, when those spreadsheets are generated, document how they're generated and who generated them. And you may also want to consider supervised access to the database, where somebody from the organization is at the keyboard, and your opponent or the requesting party is asking you for queries, and you do something in a more cooperative way. Those would be some ways to address it.
Yeah, for sure.
You said the magic word there, Mary. A little cooperation here would likely have obviated the dispute.
Mm-hmm.
Yeah, for sure. Well, and that's a running theme through a lot of our cases. And we've definitely seen cases before where we've had that kind of access to the database or supervised access to the database granted. So it's certainly not unprecedented by any means. So Tom, if this were a smaller case and not a class action, do you think a court makes the same ruling to produce the databases? If not, how should a court in a case like that handle a dispute like this?
Well, it doesn't have to be a class action to run into these issues. You can have small, individual parties going against a large corporation, and run into some of these issues. We had a big case down here that I worked on that did the class certification was rejected, and so it was a coordinated action involving a number of individual plaintiffs against a significantly sized corporation, a shipbuilder. So that can come up. I think the first thing is to make sure that the argument that the production was unlabeled, disorganized, and unmalleable, fix that. If you're going to give us a production, then make sure it's in some sort of an order that's readily available, and that can be the spreadsheets. That's fine. The other thing, the big thing that comes up with small versus big here, small plaintiff, is we can't give you a big database because you don't have the resources to deal with it. So in that case, some sort of reports or maybe an export with a load file of a limited amount of information that I can put into Relativity or Everlaw, Next Point, whatever database I'm using, would be sufficient. And the last thing that we've seen happen quite a bit, it happened in the case I just mentioned, and another one where Craig Ball was actually the discovery master, is a direct inquiry of the other side's database. Let us get an expert and sit down at a keyboard and make some queries, make some limited queries with your network people there. In the shipbuilding case I was involved in, the judge ordered that. Let us send an expert in and sit down and make some queries under the direct supervision of the other side's IT staff. And the one I mentioned with Craig, he did the queries himself, and sat down and then dispersed them out to the individuals. So there's ways to work around it. It doesn't have to be a barrier.
Nope, indeed. And we could go on, but we have 4 minutes to cover one more case, and it's a pretty big one. Our last case, as the producers of the True Crime show Dateline would say, is ripped from the headlines. And hat tip to David Horrigan, who discussed this case in the judicial panel at Relativity Fest earlier this year. Here, Eric Lyle Williams, an inmate on death row in Texas who was convicted in Texas State Court of capital murder, filed a petition for a writ of habeas corpus under 28 U.S.C. 2254 in the U.S. District Court for the Northern District of Texas, raising 13 claims related to various alleged due process and Brady violations, ineffective assistance from counsel, and more. In Claim 9, Williams claimed the state violated Williams's due process rights under Brady by failing to disclose material impeachment evidence pertaining to a key state penalty phase witness, which was Williams' ex-wife and co-defendant, Kim Williams. Dateline broadcast 2 episodes related to the murders. The episodes were largely the same, except the latter episode featured an interview with Kim Williams in prison, where she made comments that differed from her testimony. After the Northern District of Texas granted Williams's request for discovery over the opposition of the state, Williams issued a subpoena to NBCU seeking all footage of the interviews recorded in the production of the 2 Dateline episodes, including those that were not included in the final episode, complete and unedited, and any existing transcripts of those interviews, including but not limited to interviews with eventually 9 individuals who appeared on camera in the 2 aired episodes. NBCU objected, relying in part on the journalist's privilege. New York District Judge Louis Lehman, hopefully I pronounced that one right, concluded that the unaired proportion. Nope, I didn't. It's Lyman.
Lyman.
Okay, man, I'm 0 for 2. I looked them both up too. Darn it. Okay. Anyway, it concluded that the unaired portions of the Kimberly Williams interview were likely relevant to the significant issue of whether the state withheld impeachment evidence based on reasonable inferences drawn from the aired content itself as follows. The aired interview contained direct contradictions of her sworn penalty phase testimony, particularly regarding a celebratory state cookout after the murders. She claimed on Dateline that this was taken out of context and part of a pre-planned family Easter tradition, not a celebration. Also, she testified at trial that the mood was happy, joyous, but told Dateline that while Eric Williams was happy, she was so sick and didn't eat that weekend. She stated that prosecutors told me not to cry on the stand, and she described her mind as very cloudy at the time of the events due to heavy drug use, stating, "I was pretty much a zombie." In contrast, Judge Lyman found that Williams' arguments for the relevance of the other 8 interviews to be the very definition of a fishing expedition. Judge Lyman also determined that information for Kim Williams was not reasonably obtainable elsewhere, as a deposition wouldn't be practical. And he flatly rejected NBCU's argument that producing the Dateline outtakes posed an undue burden. And NBCU estimated a minimum of 30 hours of labor to review and produce the 12.4 hours of raw footage for all 9 interviews. And Judge Lyman was not moved by a burden of 30 hours, let alone the smaller fraction needed for the single interview of Kimberly Williams. So he granted movement's motion to compel compliance with the subpoena and related to the Dateline outtakes of the Kimberly Williams interview, while denying the motion to compel for the other 8 individuals. So, Mary, do you agree with the court that the request for outtakes from the other 8 interviewees is a fishing expedition?
I do. I think they put the bifurcation of what was appropriate and what was a fishing expedition right in the opinion. Certainly, William's wife contradicted her sworn testimony, and so there was clear relevance. But the others, it was speculative, and so that's, I guess, the definition of a fishing expedition.
Yeah, yeah, indeed. Tom, NBC provided a pretty detailed estimate of a minimum of 30 hours regarding the burden of producing the outtakes, which did not move the court. So is there an argument here that they should have maybe been less specific in their estimate?
I think the judge in his wordings at one point was looking for more detail, actually, not less. He said, quote, NBCU does not provide a breakdown of those hours by interview subject, end quote. So I think he was looking for a little bit more detail in a specific manner that he didn't find. And then he also noted, of course, that they had repackaged and re-aired the materials twice since the original show airing. And so what he was saying, I believe, was they don't seem to have any trouble working with this data. That's what they do.
Right. Yeah, exactly. And of course, they said a minimum of 30 hours, and he seized on the 30 hours part, not the minimum of 30 hours part. So,
right.
So, yeah.
And when you're dealing with Dateline and an entity as big as NBC Universal, 30 hours, I mean, it's not 300 hours. It's not, going to cost $1 million. It just on its face doesn't sound very burdensome.
Yeah,
no, that's for sure. So Judge Peck, this is the first case, at least as far as I know, where we've discussed the journalist privilege. Given that Judge Lyman noted that the standard for relevance to overcome the journalist privilege is low, what could Eric Williams and his legal team have done differently to make a better case to obtain access to the outtakes from the other 8 interviewees?
Would have been better if instead of what seemed to be fairly generic arguments as to the other people besides the ex-wife, they came up with contradictions from the actual broadcast versus what those folks had testified to at any of the court hearings. In a habeas case, you very rarely get any discovery from the government. You don't get to go out like a normal civil litigation, even though technically a habeas corpus petition, even involving a death row inmate, it is a civil proceeding, not criminal, but you don't get all the discovery and you don't get depositions. So it's sort of interesting that Judge Lyman said, if there were a deposition of her, she could have invoked her Fifth Amendment right, but I don't know that there would be any deposition of her or her, the ex-wife, or any of the other targets here. So it would just be, getting whatever you could from the broadcast, getting whatever might have been in local newspapers or whatever, getting something to show that there might be something relevant in the outtakes, but just saying these people were key witnesses or whatever, so I need to know everything they said. You don't want to disincentivize news organizations from doing investigative reporting, and you don't want them to become an arm of either the state or of the plaintiff in a habeas petition. Whatever they air, that's one thing. Going for the outtakes is, I think, however low the burden may be, there's still got to be something specific there.
Yeah, that makes perfect sense. So, all right, now for the contacts page, we do have a couple of a comment and a question real quick. I'll circle back to Sheila Grilla, databases, accounting records, and CRM systems would be a great subject for a webinar regarding practical skills. Couldn't agree more. Have to take a look and see what we can do about that, Sheila. And then a question from earlier, back to the the hyperlink files case. What if your client doesn't archive versions of cloud-based docs and only keeps the current version? And what about the storage burden of keeping numerous versions of all docs? And I'll take a stab, and then others can weigh in if they want. Certainly, you can't produce what isn't there. That's one of the kind of the assumptions I've made early on, and as this debate kind of got going, is if the versions aren't there, you obviously can't worry about that. But I will say that the storage burden of keeping numerous versions of all docs, technically, if you're physically attaching files, you're storing those files possibly multiple times. So I'm not so sure that the storage burden is necessarily any different, given that some of these platforms are basically preserving the version of the file, like, for example, M365, when you do send a link to it. So any thoughts from any of the three of you?
Well, I'll go back to what I say quite a bit about this subject. If that's the way you archive or not archive, that's fine. That's the way you do work in the ordinary course of business. However, once the duty to preserve arises, I think you then become legally obligated to, if not archive, save those versions going forward from that date. That's just my opinion. The storage burden, again, if they're electronic documents, I don't know the storage burden is going to be all that onerous.
Yeah. Yeah. I mean, it's definitely, again, I think it comes down to your duty. And it's definitely different before litigation and then during litigation.
Yeah.
So as Holly mentioned at the outset, we do have a date for our next webinar, which is, in a holiday miracle, not on a Monday, but on Thursday, December 18th, where we'll discuss the most important cases of the year. So with that, I'll say thanks to Mary, Tom, and Judge Peck as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we also want to thank you, Tomo, and the Honorable Judge Peck for this insightful presentation. Thank you to the EDRM community for your kind attention. And as you are doing, if you enjoyed today's presentation, show our faculty some love, explore the resources at the bottom of your console, and share an emoji or reaction. And we look forward to seeing you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Thanks, everyone. Happy Thanksgiving.
All.